And here's a little more, written information about both Mitch and Blake as well. So now kind of shifting to the main topic of today's discussion, challenges for non-immigrant visa holders. So I guess to start, Mitch, maybe kind of give us some context. What is a non-immigrant visa, and why does that matter? And then let's kind of run through these four major buckets and what the issues are for each one, because I'm sure many of our attendees fall into one of these buckets.
Great. But even before we do that, I'd like to take a further step back and just talk about the overall topic today, because it's as conceived, it's a little broader than that even. So our approach to EB-5 is that it does not take place in a vacuum. We kind of provide a 360-degree view and analysis of a client's situation. So what visas they might have previously had in the US, what visa, if any, they're currently on in the US, maybe what changes of visa status are possibilities in the future. And all of these three moving parts has to be incorporated into a holistic EB-5 strategy, because of the life cycle of a typical EB-5 case is a number of years, depending on the country of birth. So we always want to make sure we have one eye on where they've been, where they are, and where they're going during the process. So it's unusual that an EB-5 applicant is overseas and will remain there until the EB-5 immigrant visa appointment comes up at their closest U.S. consulate. Usually during that period of time, during these number of years, they want to visit the U.S., they want to go to school in the U.S., they want to temporarily work in the U.S. So we have to make sure that all those angles are sufficiently covered. So just I'll go through a couple of these, and then Blake will jump in on a couple as well. So the B1, B2 is a non-immigrant visa. So the EB-5 is a pathway to an immigrant visa, which is a green card. So there's the permanent side of the equation, then the temporary side of the equation are these various non-immigrant visas. So they're not immigrating. So permanent, temporary. So B1's the first one. It's not a robust non-immigrant category at all. It's just for visitors. There's two types of visitors. The B1 is a business visitor. Doesn't mean they can work here. They could attend meetings, business meetings, meet with accountants, meet with lawyers, meet with regional centers, tour a particular project, go to an annual meeting, go to a conference, can't get paid here, and can't work in the US. So they're still gainfully employed overseas. That's a B1. B2 is a visitor for pleasure. So coming here to go to Disneyland, go to Disney World, just touring around. So the issues that come up as B1s and B2s interact with EB-5 is, okay, now I'm in the United States on one of these B variety visa statuses. I heard about this thing called concurrent filing. Can I file for EB-5 and adjustment of status, which is the application for the actual green card status? Big red lights and cautions. I wouldn't say that it's prohibited and never permissible, never safe to do. But anyone considering adjusting their status off of a B2 really needs to sit down with experienced EB-5 and AOS, adjustment of status counsel, just to make sure that they don't cross the line on the intent issue. So when a B person enters the US, they're swearing up and down basically that their intent is just to visit, just to go to Disneyland, just to attend that meeting. And here's my round trip ticket, I'm going back home. So if the facts change and they start applying for green cards, that's when you really need to get good advice from counsel. So a slightly more robust non-immigrant category is the F1 visa, which is really, really common. It's a common use case for EB-5. So F1s are for academic students, foreign nationals that are academic students. There's another type of student visa called an M1 for vocational students. We don't see many of those, so we'll focus on the F1. So the F1 status is good for as long as they're a full-time student. So on their entry card, it usually has a durational indication of DS, duration of status. So as long as they're maintaining valid student status. So F1 is very common, to file for EB-5 in conjunction with a concurrent adjustment of status, or AOS filing. So the AOS piece of that puzzle has three components to it: work permit, advanced parole, which is travel permission, then the green card application itself. So with F1s applying for AOS, another serious conversation needs to be had with experienced counsel, just to make sure there's no intent issues there as well, similar to the B1, B2. Blake, you want to talk about the H's and L's and how they differ in this context?
Yeah, absolutely. So these are two of the primary kind of workhorse visas that people will be on in the United States if they're working for a U.S. employer or company. H-1B, very, very common work visa, but they're really hard to get. Every year there's a cap of them. You've got to go through this lottery. This year's lottery was super, super dismal as far as the percentage of selection. And then, of course, you're tied with that employer who sponsored the visa for you. The visa itself is for generally kind of professionals, so any job that requires a degree in a specific field, and the candidate must have a degree related to that position. The L1 is an intra-company transfer visa, so this is somebody who has worked for a foreign entity outside of the United States and is transferring to a related U.S. company. So ABC Corp in India is transferring someone to ABC Corp in the United States. And so that has to be for an executive, a manager, or a specialized knowledge position. Both of these visas, they've got limits on how long you can stay. Okay, so the H-1B, you can only stay for 6 years. It's got a maximum period of time to stay. Sometimes you can extend beyond that if you get far enough along in the green card process. L1s, they have maximums too. The specialized knowledge L1 has 5 years, and the manager L1 is only 7 years. Okay, so these are some problems with those visa categories. And if you file an EB-5 and adjustment in the U.S. on those visas, well, you know, you can get work and travel permission with those, and maybe those maxes don't matter to you anymore. Another good thing about the H-1B and the L visas is these are dual intent visas. So as Mitch mentioned, the B visa and the F visa, these are non-immigrant visas, and these are really strict non-immigrant visas. If you go for a green card and you've got that immigrant intent, it has some conflicts with those visas. But the H and the L are considered dual intent. The government won't really care if you're going for a green card with those visas. Now, not everybody can just go out and get an H or an L visa, but those are some considerations we always factor in the really big picture of things when we're talking about EB-5 with clients.
Interestingly, how a common scenario for an L1 would be, first, we put together the EB-5 application, especially if they're from a high demand country. We want to get an early priority date. Right now, there's no backlogs at all, but that's not going to last forever. So if someone's in India, for example, working for a sizable company, they have a U.S. subsidiary or thinking of launching a U.S. subsidiary. What we recently just did is put together what we call a loose EB-5 petition, not concurrent filing because the person's not even in the U.S. Get it filed, get a priority date. And then now we're working on the L1 application. So once that L1 petition gets approved, they take that approval notice to the U.S. consulate. They get an L visa stamp in their passport. They enter the U.S. And because L is a dual intent non-immigrant visa, we could immediately file AOS the next day. There's no intent issue at all. So there's no artificial delay there. Same with an H1.
For you guys, that we've been asked by a lot of different investors, and you mentioned it earlier. So I'm on H1B now. I file my EB-5, I adjust status, I get my work authorization, and let's say that I do lose my job. How important is it for your EB-5 petition, both the 526 and the 829, to eventually be approved? Like, is this something where you can go back to the H and refile if it isn't approved, or should you be really focused on making sure you choose a project where as much immigration risk as possible has been minimized to make sure that there's no issues in the future?
They can adjust their status to conditional and then get the conditions removed without being in H status, but it's always kind of an insurance policy to try to maintain it to the greatest extent possible. If they have to lose it, maybe they lose their job and the next employer, as I previously mentioned, for some reason does not want to continue picking up the H status. Although they're still in what we call AOS pending status with employment authorization and the ability to travel, if later on that employer or another employer is okay picking up H status, with some maneuvering, we can regain H status. They might have to depart the U.S. and then re-enter. If the H visa stamp in their passport's expired, they may have to get another one. But it is possible to regain H status after having lost it, but it's not critical in the life cycle of EB-5.
Okay, got it.
Another real a good benefit that came up recently in one of our cases in concurrently filing is with regard to aging out children. So once AOS is filed, let's say by the dad or the mom, and they have 2 or 3 kids, and one of the kids is 20 years old, as long as the AOS was filed before that child turns 21, that age is forever frozen. There's no risk of defrosting that age at a later point if there's a stop and start in the process. This is a little different than how the CSPA, the Child Status Protection Act, works on what we call a loose EB-5 filing. If they're abroad, I won't get into too many weeds, but it's a permanent fix if they're all in the U.S. having concurrently filed AOS. So it just eliminates the risk of aging out.
And maybe one thing to kind of dovetail off where Mitch mentioned this consular filing. So that is an option. You know, if someone's in the U.S. or they want to be in the U.S., the EB-5 with the adjustments, a great method to get you here, or if you're here, keep you here, give you that additional layer of EAD and advanced parole while you're waiting for the green card. Of course, ultimately get the green card. But some people might be abroad or might need to spend a couple more years abroad, and they want to do EB-5, and so you do this consular process. You still need to keep in mind some of these other non-immigrant visa categories we've been talking about. If you're someone who loves to travel to the U.S. every year and just visit, go wine tasting, Disneyland, whatever, that 526 filing might impact your ability to get a visitor visa or to travel to the U.S. because you've got that immigrant intent now, and you've got to explain that to customs. You have to say, yeah, it's an EB-5, but it takes a long time to get the green card through consular processing. I'm going home after this trip. I have no immediate immigrant intent to get the green card this trip. So you might have to do some explaining if you're on a B1 visa, or can you get a student visa? So if the investor's young and they want to go to school in the U.S., can they be issued an F1 visa with that immigrant intent? Okay, so when you're doing the EB-5 process, it's not just important to consider the visa you're currently on in the United States, but for a foreign investor doing consular processing, you've got to think about their life and do they come to the U.S., will they want to, and what their options might be for one of these other non-immigrant visas.
Let's shift gears a little bit and talk about some of the implications of the new RIA law. Mitch, do you want to just kind of walk us through what some of those major changes were other than adjustment of status, and then we can talk a little bit more about how rural is differentiated now between non-rural projects.
Yeah, well, keep in mind the letter I in RIA. So it's the Reform and Integrity Act. So a big part of the RIA applies to projects and regional centers like EB-5AN. So they have much more rigorous protocol that they have to undergo and maintain in order to keep their regional center status. So there's more reporting requirements and site visits and just tightening up the whole ecosystem on the project and regional center side, which is really good for the whole industry. There's been problems historically, and this is a direct address on some of those issues. So the regional centers that have remained, and they have to submit exorbitant filing fees just to maintain their regional center status. So the ones that are remaining are generally viewed as the stronger ones. So a lot of the ones who are just dabbling in it are gone. So that's the I in RIA. So the RIA also came up with these 3 targeted employment area segments: rural, high unemployment, and infrastructure. So there's 10,000, just to give very general numbers without getting too far into the math with spillover numbers, which expands the numbers. So there's 10,000 EB-5 green cards issuable or available per year. No single country can get more than 7%, so that's 700. And they divided that into these 3 categories. So they have these, they set aside a certain percentage of those 10,000 for these 3 subcategories: rural, high unemployment, infrastructure. So 20% of the set-asides are allocated to investors in rural projects. 10% of the set-asides is allocated to investors in high unemployment, and 2% in infrastructure projects. We haven't really seen an infrastructure project on the market, or at least none of our investor clients have found one and selected one. So mostly it's rural and high unemployment are the 2 big games in town. The benefit of rural is that the RIA indicated that those EB-5 applications based on a rural investment are to receive what they call priority adjudication.
Got it.
Yeah.
Got it. I guess, Mitch, going back to the visa bulletin, one thing that's kind of unique about this current situation where India, China, and all the other countries are current is that, there effectively can be an unlimited number of investors who do EB-5 who are already in the US, mm-hmm. who could get that work permit and travel permit. So,
Sure.
Even if there is a visa limit for the EB-5 green cards, there's no limit on adjustment of status. So what will likely play out over the next few years here is, many people will do the investment, and then they'll all be able to get the work permit quickly. And maybe some of the investors, the ones who are late and who invest kind of towards the back of the group, will face a delay later when mm-hmm. their I-526E gets approved in terms of collecting the green card. But as long as it's current when they apply initially, they'll all be able to get the work permit. And so it's just going to be a difference in timing of actually collecting the green card itself.
Yeah, that's right. The way I describe it to clients, Sam, is just by being able to file the 526E concurrently with the AOS, and as you said, they can any number of people can from any country right now can file all day, every day. There's no limit on the number who can file. Once they get an extendable work permit and an extendable advanced parole, those 2 things combined is really 95% of the value of a green card. So as you said, they may actually get the green card status under the wire before it backlogs if they're from India or China. But if not, at least they have an extendable work permit, an extendable travel pass, so they can continue to work anywhere, travel anywhere. And then one day they'll be happy to find the green card in their mailbox when their turn is finally reached on this future waiting list.